गुजरात हाई कोर्ट में हाल ही में 8 न्यायाधीशों की नियुक्ति हुई है। लियाकत हुसैन, शमसुद्दीन पीरजादा, रामचंद्र ठाकुर दास बचानी, जयेश लखनशी भाई ओडेद्रा, प्रणव महेश भाई रावल, मूलचंद त्यागी, दीपक मानसुखलाल व्यास, उत्कर्ष ठाकुर भाई देसाई और रोहन कुमार कुंदलाल चूड़ावाला। इन नियुक्तियों के साथ यह देखना महत्वपूर्ण होगा कि क्या ये नए न्यायाधीश राज्य में लंबित महत्वपूर्ण मामलों पर प्रभाव डालेंगे, विशेष रूप से वे मामले जो प्रधानमंत्री नरेंद्र मोदी और गृह मंत्री अमित शाह से संबंधित हैं। न्याय की नई किरण या वही पुरानी धुन। गुजरात हाई कोर्ट के गलियारों में एक नई हलचल थी। 8 नए न्यायाधीशों की नियुक्ति की गई थी और उम्मीद की जा रही थी कि न्याय की प्रक्रिया में एक नई ऊर्जा का संचार होगा। लेकिन क्या वास्तव में ऐसा होने वाला था या सिर्फ एक और दिखावा था? पहला अध्याय, न्याय की नई बयार। पहले न्यायाधीश थे लियाकत हुसैन शमसुद्दीन पीरजादा। उनकी नियुक्ति पर कुछ लोगों ने सवाल उठाए क्योंकि उनकी पृष्ठभूमि में कुछ विवादास्पद फैसले शामिल थे, लेकिन सरकार ने उन्हें न्याय का प्रतीक बताकर उनकी नियुक्ति को सही ठहराया। दूसरे न्यायाधीश थे रामचंद्र ठाकुर दास बचानी। अपने कठोर और अनम्य रुख के लिए वे जाने जाते थे। उनकी नियुक्ति पर भी कई लोगों ने चिंता व्यक्त की क्योंकि उनकी न्यायिक दृष्टिकोण में लचीलेपन की कमी थी। जयेश लखनशी भाई ओडेद्रा, तीसरे न्यायाधीश, अपनी राजनीतिक संबंधों के लिए प्रसिद्ध थे। उनकी नियुक्ति को लेकर सवाल उठे कि क्या वे निष्पक्ष न्याय कर पाएंगे या उनके फैसले राजनीतिक दबाव में होंगे। दूसरा अध्याय, लंबित मामलों का बोझ। इन नए न्यायाधीशों की नियुक्ति के बाद गुजरात हाई कोर्ट में कई महत्वपूर्ण मामले लंबित थे, विशेष रूप से वे मामले जो प्रधानमंत्री नरेंद्र मोदी और गृह मंत्री अमित शाह से संबंधित थे। उदाहरण के लिए 2002 में गुजरात दंगों से संबंधित मामले, जिनमें नरेंद्र मोदी को SIT द्वारा क्लीन चिट दी गई थी, लेकिन फिर भी कुछ याचिकाएं लंबित थी। इसके अलावा सोहराबुद्दीन शेख फर्जी मुठभेड़ मामला, जिसमें अमित शाह आरोपी थे, अभी भी न्यायालय में चर्चा का विषय बना हुआ था। तीसरा अध्याय, न्याय की प्रतीक्षा में जनता। न्याय की उम्मीद में बैठे लोग बस यही सोचते हैं कि क्या कभी सच में न्याय मिलेगा या सिर्फ एक सपना बनकर रह जाएगा। 8 नए न्यायाधीशों की नियुक्ति के बावजूद मामलों में सुनवाई में देरी जारी रही और जनता की उम्मीदें धीरे धीरे धुंधली होती गई। चौथा अध्याय, न्यायपालिका की चुनौतियां। न्यायपालिका में भ्रष्टाचार, राजनीतिक दबाव और प्रणालीगत खामियों के कारण न्याय की प्रक्रिया में बाधाएं आती रहीं। नए न्यायाधीशों के सामने यह चुनौती थी कि वे इन बाधाओं को कैसे पार कर पाएंगे और न्याय की प्रतिष्ठा को कैसे बहाल करेंगे। पांचवां अध्याय, उम्मीद की किरण। हालांकि चुनौतियां बड़ी थी, लेकिन कुछ न्यायाधीशों ने निष्पक्षता और साहस के साथ अपने कर्तव्यों का पालन किया। उन्होंने दिखाया कि यदि इच्छा शक्ति हो तो न्याय की प्रक्रिया में सुधार संभव है। न्याय की नई सुबह। यह कहानी एक कटाक्ष है उन व्यवस्था पर जहां नए चेहरे तो आते हैं, लेकिन व्यवस्था की जड़ें इतनी गहरी होती हैं कि कुछ भी बदलता नहीं। फिर भी उम्मीद की एक नई किरण हमेशा बनी रहती है। एक दिन न्याय की सुबह जरूर आएगी। ये कहानी हमें ये सोचने पर मजबूर करती है कि क्या हम वास्तव में न्याय की ओर बढ़ रहे हैं या सिर्फ धुंध में रास्ता खोज रहे हैं।
Give due consideration to the said model law, not something else. That said model law, in view of the desirability of uniformity of the law of arbitral procedures and the specific needs of international commercial arbitration practice, and whereas UNCITRAL has adopted the UNCITRAL conciliation rules, and whereas General Assembly of the United Nations has recommended the use of the said rules in cases where a dispute arises in the context of international commercial relations and parties seek an amicable settlement of that dispute by recourse to conciliation, my lord will see then. And whereas the said model law means the 85 model law, makes significant contribution to the establishment of a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations, whereas it is expedient to make law respecting arbitration and conciliation by taking into account the aforesaid model law and rules. This last paragraph is as clear as can be. It has been made. Yes.
You read para 3 of the SOR also. Para 3 of the statements and objects.
Yes, please, I'll come to statement. I'll start with paragraph 1 because even that is relevant. The law on arbitration, because all of it has to be read. Of course, judgments. I'm trying to show that this was not some willy-nilly endeavor done in the blind, unaware of what UNCITRAL decided, and we had a different thing in our mind as to what setting aside means. Everyone in 1985 and 1996 was very clear, and Parliament was certainly very clear as to what setting aside means. It has a specific context and a meaning in international law, Millets. It is not just the 1996 Act. Even prior to that, the Foreign Awards Enforcement Act, Millets, the 63. The 40 Act, all of these had the concept of setting aside. Parliament was aware. It's not a new concept suddenly accidentally filtering in to domestic arbitration to the root of international law. No, that is not the case. Parliament was aware, and therefore my lord will see the statement of objects and reasons. The law on arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940, the Arbitration Protocol and Convention Act of 37, this is the Geneva Convention, and the Foreign Awards Recognition and Enforcement Act 61, the New York Convention. It is widely felt that the 1940 Act, which contains the General Act of Arbitration, has become outdated. So an attempt to move away from the 40 Act, and instead the power modification is now read in, it will become like the 1940 Act again. So the attempt of the legislature to move away from the 1940 Act is effectively being argued against, which contains the general law of arbitration become outdated. The Law Commission of India, several representative bodies of the trade and industry and experts in the field of arbitration have proposed amendments to this act to make it more responsive to contemporary requirements. It is also recognized that our economic reforms may not be fully effective if the law dealing with settlement of both domestic and international commercial disputes, but both, remains out of tune with such reforms. The intention is very clear. Like arbitration, conciliation is also getting increasing worldwide recognition as an instrument for settlement dispute. Therefore, there is however no general law. I'll read the whole thing. I'll read 3 as well. The UNCITRAL adopted in 1985 the model law on international commercial arbitration. The General Assembly of the United Nations has recommended that all countries give due consideration to the model law in view of the desirability of the uniformity of the law. Again, they want every domestic municipal jurisdiction to have the same law. Which law? Which is the 1985 model law of the law of arbitral procedures and the specific needs of international commercial practice. The split millers is you generally adopt this where there is some variation. Therefore, we have part 2 of our act. The UNCITRAL also adopted in 1980 a set of conciliation rules. The General Assembly of the United Nations has recommended the use of these rules in cases where parties arise in context of international commercial relations, parties seek amicable settlement by recourse to conciliation. And important of the UNCITRAL model law is they have harmonized concepts of arbitration and conciliation of different legal systems of the world, and thus contain provisions which are designed for universal application. All across the world, setting aside means setting aside. When it doesn't mean, provide for a difference. If we want harmonization, we can't in India say
that harmonization is something different. What they're saying is apply the same law, but the fact of the matter is several countries, including the Western world, where arbitration is perhaps the default mode in commercial arbitration, commercial matters, they have power of modification.
no, that is statute.
You can't argue that if you bring in modification, you'll be violating the international.
No, that's not what I'm saying. What I'm saying is a particular I'll read this line again as to what I'm trying to say. What I'm trying to say is that the UNCITRAL Act and our Act was.
You may be right to that extent. You may be right to that extent. But during the course when the discussions was going on, whether model international law of international. At that time, they said modification should not be. There was debate whether modification should be included or not, and they left it. They left it at that.
Yes. Look, what I'm trying to say is, what does the word setting?
Paragraph 3, it is clear that
Yes.
they did not want to lift it as it is for the domestic arbitration.
I'll read paragraph 3. Let's read this. But while reading paragraph 3, we can't forget the last line of paragraph 2, that the intention is to actually adopt that 85 model law
As a model law,
as a model law.
with certain modifications necessary to
Certainly. But Millers,
suit the domestic needs.
unfortunately or fortunately, none of those modifications happened. It was open to the legislature of India when adopting that 1985 model law to make suitable amendments. Where they made suitable amendments, we know. Where they've not made, they've not made. And where they've not made those amendments, we can't then say that even though you chose not to make those amendments, we will somehow read a power that there was an intent to depart from what was commonly understood. What was commonly understood in 85 and 96, setting aside means only setting aside. The legislature chooses not to depart from that. It was open to it. They chose not to depart from it. Having chosen not to depart from it, we can't say that even though they chose not to depart from it, merely because they could have means that they have. That does not follow, Millers. It was open to them to do that. And in fact, I would argue the reverse. Even though they could have, but they didn't, means that setting aside means only setting aside. Because we are sitting here in an interpretive exercise. We are not sitting here as legislators or in some kind of constituent power. If the intention is to be determined of Parliament, the intention of Parliament is very clear, whether we like it or not. The intention of Parliament is clear that what does the word setting aside mean? Setting aside, it's Lord Atkins' famous Liversidge and Anderson. Words mean what they mean. Setting aside, we all means annulment, which is why we are now struggling to find modification, variation elsewhere, which is why CPC always says modification is different from variation. The Arbitration Act says modification is different from setting aside. This concept of setting aside is conceptually different. There is no way of reading into the idea of setting aside a concept of modification. I'll come to the second argument, which is that it is a lesser or a greater power. But I'm on a point A here, which says that you cannot interpret the word setting aside in any manner other than its natural meaning and the meaning as described in Redfern and Hunter, and as understood by every country across the world, as understood by India in 1985 and in 1996. Suddenly, Millers in 2025, they can't suddenly be waking up and saying, no, actually, that's not what they meant. What setting aside meant was modification. Well, this stroke of genius that we lawyers sometimes get to read words interestingly and differently, this cannot work when the words of the statute are clear. They're as clear as daylight. We may not want it, I repeat, we may not want it, you may not like it, but there has to be some judicial discipline, Millers, also, with the greatest respect. Because, Millers, I repeat, nothing is a greater anathema to the world of commerce as unpredictability. This constant flip-flop, change, etc., Millers, is actually a greater danger. Two parties have decided that we can go to court.
I don't think that argument, the last argument was, because the commercial world also wants certainty in litigation.
Yes, Millers.
And not continuity of litigation.
Millers,
That's the argument of the other side is, why do you expect courts will not be able to be appropriately apply the law, even if it is modification, in cases where there is need and strictly within the four corners of law, without going into the merits of the matter, without going into rewriting the award. In those limited set of, they are not asking that it can be court can sit in a judgment in an appeal, and as was suggested in some of the cases, in one or two cases there is suggestion, but most of the advocates on the other side have never said that we should become the appellate court. Nobody said that, except probably in public policy matters relating to NHAI.
Well, the question is not as to what is desirable.
Nobody's arguing.
It is a question, Millers, of what is the law. That's what I am on.
Let me put it very clearly. As far as commerce is concerned, that may not be. The first argument of yours,
No, let's,
that if we have adopted the unilateral model,
yes.
and the intent of the legislature was to exactly take up the unilateral model, then setting aside doesn't include modification. To some extent, maybe right.
So look, again, just as a legal framework, is just put it back, skeleton of legal framework. You can't add words to a statute. You can give. I'm just finishing my point.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।